A very warm welcome to lesson number 28 in our 50-part series on the law of evidence. In today's lesson, we will be discussing section 27 of the Indian Evidence Act. We've already discussed sections 24, 25 and 26 in the preceding videos. It is very important for you to see those videos before you watch this because this lesson is based on the previous videos. Remember that when we are studying confessions, we see it under the category of admissions. Confessions are a special type of admissions. Admissions have been specifically defined, but confessions have not been defined in the Act. However, we had learnt that confessions are basically admissions of guilt. We'd seen that admissions suggest an inference as to a fact and issue or relevant fact, and that they are generally self-harming, which is what we gain from section 21. On the other hand, a confession is something that always happens only in a criminal case. Admissions can be in both civil as well as criminal, whereas a confession pertains only to criminal matters. It is an admission of guilt, an unequivocal admission of guilt, which means that it is very clear when a person makes a confession that he is admitting his guilt, and therefore it is always self-harming. You can refresh your memory by looking at this case that we had discussed. We'd also seen section 24 of the Indian Evidence Act, which tells us that confessions should be made freely. If a confession is made because of inducement, threat or promise proceeding from a person who is an authority, and if this promise or threat is of temporal nature, then in that case the confession is not relevant. So the confession should be made with the consent. We also saw under section 28 that once such impression of inducement, threat or promise is removed, then the confession becomes relevant again. We had also seen Article 20. Article 20 contains 3 subclauses, but for our present purpose, it is good for us to just know Article 20 subclause 3, which means that no person can be compelled to be a witness against himself. This is the right against self-incrimination. Then we studied section 25 and 26 in our previous lesson, lesson number 27. Both of these deals with confession and the police. Section 25 deals with confessions that have been made to a police officer. Section 26 deals with confessions that have been made in the custody of the police officer. In case you require to refresh your memory, go back and watch that lesson before continuing any further. Now we begin with the main topic of today's discussion, which is section 27. At this point, I'd like you to pause the video and have a look at section 27 by your own self before proceeding any further. When you look at section 27, then there's something very interesting that happens in the very beginning of the provision itself. It starts with the words provided that, which basically means that this is of the nature of a proviso. Okay, so a proviso is something that basically supplements or controls what has been said before that, right? So you've seen this often, that there might be a section and that section is then followed by a proviso, and that proviso controls or limits what has been said in that section. In this case, the section itself is starting with the proviso, right? So what is it a proviso to? Obviously, it has to be a proviso to something preceding it. Okay, so you have section 27 that starts as a proviso, and therefore it is important for you to know that it controls something preceding it. What are preceding section 27? Well, you have the sections from 1 to 26. So what does section 27 apply to? So in the leading case of Agnu Nagesha versus the state of Bihar, the Supreme Court has said that section 27 operates as a proviso to sections 24, 25 and 26. Okay, so 27 controls what has been said in 24, 25 and 26. Therefore, you see it's very important for you to go ahead and read 24, 25 and 26 before you delve deeper into this lesson. Now let us read section 27. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, So much of the information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. As you can see, this is a long sentence, so let us break it down. Okay, first let us see this initial part here. Fact is deposed to as discovered. Now what is the meaning of fact is deposed? Deposition, when you say something is deposed or a deposition, is basically something which has been made before the court, a statement which has been made before the court. So what you can see here is that the main essence, the essence of this section is that when a fact, a certain fact has been deposed, it may be proved. You see, you get the main idea of what section 27 does. Let me tell you why. What did we see in sections 24, 25 and 26? These three sections told you that some things cannot be proved, right? Section 24 said that when there's a threat inducement, you cannot prove it. 25, confession to a police officer cannot be proved. Section 26, confession in the custody of a police officer cannot be proved. Now what is section 27 doing? 27 is acting as a proviso. If it is acting as a proviso, obviously it will qualify what has been said earlier. It might go slightly to the opposite, slightly to the contrary. So you can see that basically what section 27 is doing is that it makes a certain fact capable of being proved, which means instead of saying that it cannot be proved, it is saying that it may be proved. So that's the first step of our learning. Now let's see if we can get some more information from section 27. Okay. Now you can see it says that when any fact deposed to as discovered in consequence of information received from a person accused of any offense. So the information is given by a person who is accused of an offense, and now you find something, that fact, this fact here, the fact which may be proved, right, is as a result of the information that has been given to the police officer. Okay. Now, is the information something that may be proved, or is the fact something that may be proved? Take a moment, pause the video, and as you can see, there are two pieces of information, two facts here. The first is the information that is given by the accused. The second thing is the fact which is deposed. Okay. Now, is this may be proved relating to this information, or is it relating to the fact? So as you might have seen, this relates to the information, right? So what you basically get from here is that there is a certain amount of information, a certain kind of information that has been given in the custody of the police officer. Okay. So there is information that has been given in the custody of the police officer, and then such information may be proved. So we saw in section 26 that information given in the custody of a police officer cannot be proved. However, the proviso section 27 is broadly talking about some information which is given in the custody of the police officer, whether it amounts to a confession or not, which means even if it is a confession, it still may be proved. Therefore, you can say that section 27 definitely is acting as a proviso. Let us now try to see section 27 in a little more detail by breaking it down. So to simply look at the words that are given in section 26 in a diagram, we start off with information, right? So this confession is basically the information. In the section you've seen the words information and fact. The information, as you can see in section 26, can either be confession or it may not be a confession. So for the time being, I am just using it as a confession for the ease of our understanding. Okay. Then there is a discovery of a fact as a consequence, in consequence of this confession. Okay. Then this information or confession is relevant. And remember, this confession was made in the custody of the police. Okay. And it is only relevant to the extent that it relates to the fact that has been discovered. And as I said, This is despite the fact that you have sections 24, 25 and 26. Therefore, 27 is a proviso to these sections, because if you did not have section 27, then anything that was said in the custody of the police was hit by section 26. Let me give you a very simple example to make you understand this point. Let us say there is a confession made by a person who is in the custody of the police. Okay. Now, as a result of his confession, where he says that, okay, I killed this person with a knife, and after killing that person with a knife, I put the knife underneath a tree. Okay. That tree was a banyan tree that was adjacent to the place where I killed him, and he gives a description. Now, as a consequence of his confession, if the police discovers a knife, okay, now that confession or information that was given by the accused is relevant, okay, because this was discovered as a consequence of the information given to the police, right? But suppose he says 20 things, okay, in his confession, he says 20 things. Only the fourth and the fifth point relate to the knife. Then only those two pieces of information are relevant. The rest of them would still be hit by section 26 because he's in the custody of the police. I hope you get the point. So what we'd seen was, suppose somebody makes a confessional statement in the custody of the police, then that is hit by section 26. It is not relevant. However, whatever points that he says, let us say two of these points, they relate to a fact that is discovered as a consequence of what he said. In this case, they found the knife, the murder weapon with which he had killed. Then those two parts, those two pieces, or that extent which relates to the discovery continues to remain relevant. And therefore, as you can see, it acts as a proviso to sections 24, 25 and 26. Now I'd like to highlight something very interesting in section 27. As you can see, it has to be discovered in consequence. Now, what is the meaning of a discovery? When you say something is an invention, it means you've made it, right? The scientist has invented something, which means that it was not already there. The scientist made it. So maybe a mobile phone was invented. However, a discovery is something which relates to something which was already there. So for example, if someone discovers oxygen, or someone discovers America, right, or someone discovers some other land, the landmass was already there. It's just that somebody comes to know about it for the first time. That's what a discovery is, that it is known for the first time. If something is already known, then you cannot rediscover it. So nobody can discover oxygen anymore because it has already been discovered. So this is given in the act as well. Suppose if the dead body is recovered based on information that was already known to the police, then it is not a discovery because information is already known. And this has been said in the case of State of Haryana versus Jasbir Singh. So I hope you get the point and the significance of discovered in consequence. The discovery should happen because of the statement that was made by the accused. In case it is already known to the police, then it does not fall within the purview of section 27. In our previous lesson, we'd seen with regard to section 25 and 26 that 25 deals with the subject of to whom the confession has been made. It does not talk about where the confession has been made. On the contrary, section 26 talks about where the confession has been made, that is basically the custody of the police, and it does not talk about to whom it has been made. So now let's see what happens in section 27. In fact, I'd like you to pause the video and think about it by your own self first. So these are three questions that we have with regard to section 27. Pause the video and ask yourself as to which of these questions is answered in section 27. Okay, let's take the first question. The first question is, to whom is the confession made? When you look at section 27, it does not talk about to whom it is made, does not mention anyone in particular, which basically means it can be made to anyone, right? It can be made to a police officer, it can be made to a magistrate, or it can be made to anyone else, right? So when you don't have a specification, it basically means it can be given to anyone. That's the first point. So to whom, it can be done to anyone. Then, where is the confession being made? That I think is quite clear. It is in the custody of a police officer. So we answer the question of where. It is in the custody of the police officer. Next, we look at by whom. As you can see, this is by a person who has been accused of an offense. So you see, you have the 3 points with you. To whom? It can be to anybody. I hope you remember that when we talk of confession to anyone and we say confession to a police officer, this deals with section 25. Okay. When you talk about where, then when it's in the custody of the police officer, this relates to section 26. And therefore, as you can see, 27 acts as a proviso in the cases of both 25 and 26, right? Therefore, 27 applies even in the case of a confession made to a police officer. So to clarify this point, you can have a look at this decision by the Patna High Court. As you can see, it says the statement must be made by a person who was the accused. Okay. If the person is not an accused person, then the statement would not be admissible. That is the first point, because it relates to by whom, and it has to be by the accused. Okay. The next thing, as you can see here, is that when the husband goes to the police and he makes a statement, he is not in the custody of the police. And since he was not in the custody of a police officer, his statement was not admissible. Just pause the video and read this once by your own self so that you get it more clearly. I'll just proceed ahead, assuming that you will pause the video. Now, here's a very important question. What is the meaning of a person being an accused? And remember, I'm talking about this in the context of section 25, 26, and 27, because as you'd see in all of these 3 sections, they speak of the accused person, the confession made by a person accused of an offense. So who is this person accused of an offense? Is it somebody against whom charges have been framed in the trial? Or even if I take a step back, is it somebody who has been formally arrested by the police? The answer to this is no, right? Accused is not something that has to be seen so strictly. You can think of it like this: the accused is a person against whom the proceedings are being contemplated. Which means it is being contemplated, it is being thought over to have proceedings against this person, maybe because he is suspicious, and therefore it is believed that proceedings must be initiated. This has also been clarified by the Supreme Court. It says that the expression accused of any offense is descriptive. Okay, it's a very important word, descriptive. It is not defined, it is a description, okay, of the person against whom evidence relating to information alleged is made provable by this section. Okay, it's only a description. It goes on to clarify that it does not predicate a formal accusation. It does not require any such strict measure as a condition for its applicability. So accused of any offense is basically a descriptive and broad term. Okay. So now that we've understood section 27 fairly clearly, let's think of it like this. Section 27 acts as a proviso to sections 24, 25 and 26. Okay. So let us say an inducement is offered, because section 24 says that inducement, if offered, would render the confession irrelevant. But we are looking at the proviso. So let us say if inducement is offered and then a statement is received and information is received by the accused, then there is a discovery of a fact, then that statement, then that information becomes relevant to that extent, which means this statement that is given here, this confessional statement here, this becomes relevant. That's what we understand by section 27. Now, let us say we look at this a little more deeply. Same thing, it is the proviso to 24, 25 and 26. Let us say a person is threatened by a police and magistrate, because 24 uses the words inducement, threat and promise. So this time, let us say he is physically threatened by the police and magistrate. Now he goes ahead and gives his confessional statement. Okay. Now as a result of this confessional statement, the fact is discovered. Can I say that this confession is relevant because of section 27? Think about it. Okay, so the answer to this is that it is not relevant. Okay. And we have discussed one more provision in this lesson which tells you as to why it is not. Right? So I'll not tell you the answer. You have to find out the answer by yourself. I just told you that when a person is coerced, then the confession is not relevant. So basically the confession that we just saw here in this case is not relevant despite the fact that section 27 exists. So what is the provision because of which this confession is not relevant? I have briefly discussed and mentioned this provision in this lesson. So if you're careful enough, you should be able to find the answer. So I hope this lesson was of some use to you. Thank you so much for your patience. Good day.